The Chicago Bar Association was created back in 1874 as just a general resource to help attorneys network with each other and be successful in their practices. The CBA chose to set up the insurance subsidiary because a lot of the members were asking questions about what types of insurance they should tap into. Who's the best resource for legal malpractice insurance, life insurance, health insurance, et cetera, et cetera. And rather than sending those elsewhere, we figured we'd be a better resource if we just kept it all in-house and they had a familiar face to work with on a regular basis. And we think that it's very important to get the word out and let our members know that we're around to help as a resource. On top of that, we can work with any law firm or any attorney in the United States. When a law firm comes to us for a second opinion on their legal malpractice insurance policy, we're usually able to find them a lower price for the same coverage or better coverage, or in some instances, actually both. We can find a lower price for better coverage, which is obviously the end goal. Insurance is something that not a lot of people know the ins and outs of it, and maybe a smaller firm or a solo attorney needs that consultant to really keep them in line or to provide information to take it off of their plate. They have enough going on dealing with clients, collecting bills, doing everything that makes them successful in their profession. What I'm here to do is to be a resource and really to just provide assistance in something that they are not inherently an expert in.
Hello and welcome back to Chicago Talks, You and the Law. Today we're going to be having a roundtable discussion of new laws and rules coming into effect in 2024, this year, for the state of Illinois. I am your host, Max Barrick, and today I am lucky to be joined by two friends and colleagues, Charles Krugel and Helen Bloch. In 2007, Helen founded the law offices of Helen Bloch, PC, a general practice firm that is a certified female business enterprise. Her practice focuses on four areas: employment, business, workers' compensation, and defending those who have problems with the city of Chicago. In the employment and business context, Helen drafts contracts, advises on business startup, and represents clients on all sides of the employer-employee relationship, including individual employees, managers, or employers. Helen belongs to several civic and professional organizations, which include, but are not limited to, the Decalogue Society of Lawyers, where she is a past president, and Helen is currently on the board of directors for the Women's Bar Association of Illinois. Charles Krugel, or Chuck as I'm going to call him today, is also a good friend. For the past 3 years, Chuck has run his own management side labor...
23 years.
Excuse me, 23 years, thank you.
Yeah.
For the past 23 years, Chuck has run his own management side labor and employment law practice based in Chicago. His clients are worldwide and in all industries. A third of his practice is HR, human resource counseling, on day-to-day issues that come up. Another third of his practice is transactionally based, like agreements and various employment interactions. And the last third of his practice is litigation in both state and federal courts and before regulatory agencies. Chuck also represents unions as well as non-unionized companies, and he is frequently quoted and interviewed by the media. Chuck and Helen, welcome.
Thank you.
Thank you. Thank you for having us.
Thanks for being here. So Helen, let's start off with you. There are a series of new paid leave and unpaid leave laws in the state of Illinois. Can you talk to us a little bit about the paid leave laws in Illinois, and then we'll talk about some more local versions?
Sure. We'll start on the top first. So now in the state of Illinois, it's required that any employer, irrespective of size, so even if, let's say, you have one employee who works 5 hours a week, is required to provide a certain amount of paid leave. And the way the state calculates that in its law is that for every hour someone works, they earn time. And for every 40 hours work, someone gets 1 hour of paid leave. And then that can be capped at 40 hours. So if you do the math, which I'm not great at math, which is why I went to the law practice, it's calculated such that if someone works full time, they can earn essentially up to 5 days of paid leave to use for any reason throughout the year. And if the need is, let's say, foreseeable, so for instance, you know you're going on a vacation, your employer can require that you provide 7 days advance notice. If the leave is not foreseeable, such as you're sick or last minute your car breaks down and you need to take some time off to go to the mechanic, you are to contact your employer according to the law as soon as essentially is practicable, and then you're allowed to use this amount of paid leave. You need to work for your employer for at least 90 days in order to be able to use the paid leave. But once you work for your employer for 90 days, whatever you're earned, you are able to essentially use in your place of employment. And that is the state component.
That's good, and that's helpful. That was a good explanation. So you got to spend 90 days there. You get an hour for every 40 you put in. You give your employer some notice when possible, and if you don't, it gives you some guidelines on how to, that car breakdown or somebody gets sick emergency situation.
Right, sure.
Very good. And then you mentioned also Cook County and the city of Chicago, I think. Are there local versions of this?
I didn't, but you're 100% right. I started at the macro on top, but then if you go down from the state, if you live in a municipality or the county that actually has laws that are at least equivalent to the state essentially has a carve out and says follow your local law. Right now, to the best of my knowledge, there are only two. There's only Cook County, and soon, effective as of July 1st, there will be the city of Chicago, which is going to have comparable paid leave. So I'm happy to start with the county first, which is...
Your call.
Okay. The county is pretty similar to the state, so that's really the easiest. So if you live in Cook County, you're going to follow the Cook County requirements, and still, for every 40 hours worked, you're going to earn 1 hour. That's going to go up to that magic number of 40 hours, which is essentially 5 days of paid leave. You're able to take it in minimum of 2-hour increments. So for instance, your employer can't say to you, gee, you've earned 40 hours up until now. You want to take some time off to go to the doctor. You need to take a full 8 hours. You have to take a full day. The law says no in Cook County. You cannot do that. You need to allow your employees to take it at least in 2-hour increments. Did you want me to get into the city of Chicago as well?
Yeah, we're on a roll. Let's do it.
Okay, why not? So the city of Chicago has had a paid sick law that's been in effect now for some time, and that is currently in effect. But come July 1st, it's going to transition into a whole new system. And what's going to be a little bit confusing, especially if you live in Cook County and in the state of Illinois, most employers might think, gee, the calculation is 1 hour for every 40 hours worked, but that's not the case in the city of Chicago. And the city of Chicago is going to have two different buckets. So in order to earn some time off from work, the calculation is going to be for every 35 hours worked, you earn 1 hour of paid leave, but you also earn 1 hour of paid sick leave, which you can also use, let's say, if there's a school emergency and you need to go to your child's school, or your school is closed, or your child needs to miss school. So there are two buckets in the city of Chicago. And you don't have to necessarily be employed by a Chicago employer for that city of Chicago law to apply to you. So for instance, let's say there's a suburban employer that has employees who work in the city of Chicago at least 80 hours within a 120-day period. They are going to have to follow that city of Chicago ordinance come July 1st and provide up to 40 hours of paid leave to use for any reason, still with that 7-day foreseeable aspect to it, meaning if you're going to take a vacation, so it's foreseeable, you should give your employer 7 days of notice. That is similar to the state and the county. But for the sick leave, that's not the case. For those, let's say, 40 hours of sick leave, if you are to max out and earn the maximum, then it's as soon as possible. You need to give your employer notice. But if you are going to be off of work for 3 or more days, then you should give your employer a doctor's notice, especially if you took that leave last minute.
Okay, so even our suburban employers may have some things to learn about the city.
That's right.
Which I'm sure they'll be very happy about.
Oh, they certainly were. I was very busy drafting new policies and procedures to go into effect this year for the business folks.
And forgive me if I'm ambushing you with the question, but will that apply to remote employees working in the city? So somebody may be doing the reverse commute 4 days a week. I'm in Northbrook or Skokie, and 1 day a week I work from home out of my house in the city of Chicago.
Yeah, so if you're the employer that knowingly has your employee work outside of their home in the city of Chicago, and it's going to be 80 hours within a 120-day period, then you better apply the City of Chicago ordinance to that remote worker.
Okay. Chuck, let's switch gears a little bit and move away from paid sick leave and talk about, I think, what people usually consider to be an organized labor issue, but does affect other people as well. There were some changes at the National Labor Relations Board this year, but before we get to those changes, can you tell the folks listening at home what the NLRB actually is and does?
Yeah, so the NLRB is the federal agency that enforces the National Labor Relations Act. The NLRA, the act itself, was passed in 1935, often called the Wagner Act, and then it's been amended a number of times, 1947, 1959, and I think one other amendment. And basically it governs anything involving union, non-union employees, involving wages, hours, and conditions of employment that affect two or more employees at the workplace. So wages and hours is simple, obviously they're self-defining. Conditions of employment is basically almost anything that would affect a condition of employment, such as safety, bonuses, holidays, things like that. So it affects almost anything in the workplace. And the NLRB, they've been stepping up enforcement against even non-union companies now. So anything involving what they call concerted or protected activities, even if it's a non-union company. The two major changes that are going on right now relative to the NLRB is that they have a streamlined election process that they've implemented through they make rules. Like any other regulatory agency, they make rules. And one of the rules is to quicken the time for getting from A to Z for union elections. So now it used to be like it could take anywhere from maybe a few weeks or months. Now they've gotten it down to about 2 weeks to 3 weeks. The last election I had, took about 2.5, 3 weeks to get from A to Z. So that's faster. And then there's also another new rule for the joint employer rule, which is supposed to go into effect later this month, I believe February 26th of this month, but we're not really sure. It's possible that Congress or somebody may try to enjoin the NLRB from enforcing that. But basically, though, the idea is that they're trying to make two or more employers jointly liable for labor violations at the workplace, again, union or non-union. So it's the concept that basically third-party staffing companies, professional employer organizations, contractors or subcontractors can be held jointly liable along with the primary company for violations.
So just to stay with that issue, then I think if I'm hearing it correctly, maybe the hypothetical or the example you'd think of is someone's hired by a staffing agency to go work at this, that, or the other factory or blue-collar setting. Something goes wrong there, there's, God forbid, a chemical explosion or something bad happens. It's not just on the employer, the company rather, I guess, is not just on the hook. The employer, the direct employer, the staffing agency might be on the hook as well, despite, taking the position of, listen, we're only here for the people, we only manage the people here, we're not managing the place itself.
Yeah, so even if there's like a contractual stipulation that says we don't manage your people and you have sole responsibility, it's possible that the NLRB could pierce that and look at the realities, the circumstances, economic realities, they also call it, and decide that, well, if you meet one of 7 criteria, at least one of 7 criteria that that the new rule contains, then basically you're a joint employer and you're liable.
So, and then I want to talk about one other term you used. You said concerted activity. Yeah. Can you explain what that means?
Yeah, so it's any activity among 2 or more that affects one or more employees in the workplace. Generally, it's like 2 or more employees because it's concerted. It's hard for one person to have concerted activities unless they're representing or talking about violations or practices, standards that affect more than just themselves, more than just whatever conditions of workplace, wages, hours, whatever.
So you think like somebody says, hey, I think this thing is unsafe here. Maybe you think back to the pandemic. People are not masking here. I get a petition signed asking them to enforce social distancing or this regulation or that regulation. Somebody gets fired over that activity. You're saying the NLRB is the place that person might go and the body that might investigate or look into that potential violation.
Exactly. It could be for a walkout, a strike, whatever, yeah. And again, non-union too.
Okay. Anything else at the NLRB you want us to know about, changes over the last year, or mostly that?
Mostly that. I mean, one of the things with the NLRB is that, and I always say this to employers, and I've said this to the NLRB too, they like to say that they're very pro-employee. I don't really think they're pro-employee. I think they're very pro-union. So I think they'll basically, to be blunt, they'll throw an employee under the bus at the expense of a labor union or a labor association. So.
Can you, if you're able, are you able to kind of give, not an example that might get confidentiality issues going, but just an example of what that might look like?
Sure. So if one or more employees don't want to deal with the NLRB and don't want to have enforcement action taken against the employer because on principle, they don't believe in the action that's being contested or disputed, the NLRB won't care. I mean, if the employees say, like, we like our employer, everything is cool, don't do this to us, they just won't care, and they'll take enforcement action regardless of whether the employees want it or not.
Understood. So, and I think you described it was a much more aggressive NLRB now under President Biden than it was under President Trump.
Yeah, well, President Trump was actually, Trump and Obama had a lot in common, I thought, relative to employment and labor. So Biden's probably the most liberal president in our lifetime, maybe the most liberal president relative to labor ever. So yeah, it's a big difference. I find it ironic, though, that Trump and Obama were similar. So
I think they'd find that ironic, too.
yeah.
But you do see that with policies and procedures as well, that
Yeah.
the National Labor Relations Board has come out with opinions that don't necessarily govern, to Chuck's point, union activities, because they have come out with a lot of positions on, let's say, what should be in a handbook, for instance, what shouldn't be in a handbook, and what might affect what you're referring to, I think, is Section 7 rights in terms of discussing terms and conditions of employment. So that has impacted, let's say, confidentiality agreements, non-disparagement agreements, and what kind of terms can, or even if they are in employment agreements, can or cannot be enforced in even employment agreements among, let's say, professionals.
Well, big area, too, is social media communications. So they get involved in a lot of social media communications where companies, if they try to censor or limit what employees can say online or in chat rooms or whatever. And there's a distinction made between private and public social media and those types of venues. So that's one of the areas they've staked out.
Sure, yeah, and I think a lot of people have heard about speech in the workplace and how that's being policed differently and what have you. Helen, let's switch gears again and go back to you. We're going to talk about different leave and different changes now. Are there any changes to some other leave laws like VESA or anything to that effect that you want to cover for this year?
Yeah, so for instance, in the state of Illinois, sometimes I lump in a way VESA and the Gender Violence Act together for certain types of protections and situations. So VESA, as you refer to, I can never remember what the acronym completely stands for, but it's essentially sexually
Economic
Safety and Security Act.
Yeah, victim
So
economic.
basically, it pertains to, let's say, victims of domestic violence or sexual violence or stalking or whatnot. So they have certain leave rights that they are allowed to take, and some of those leave rights have been expanded. And the reason why I put that in a way together with the Gender Violence Act is because it is now clear in the state of Illinois that, let's say, the employer knew or should have known or was put on notice that one of their employees sexually assaulted, let's say, someone else in the workforce, or even, let's say, a non-employee. I mean, it could be, let's say, a customer, or let's say you have like a condominium association, and let's say someone who works for the condominium association affects, let's say, someone who's living, let's say, or it doesn't have to be a condo, it could be a rental, whatever the case may be. You can hold an employer responsible and liable under the Gender Violence Act for sexual harassment. So the VESA I kind of think about are the various leave law aspects with respect to folks who are unfortunately victims of domestic or sexual violence or stalking. And the Gender Violence Act is the one that you're going to hold an employer responsible if they didn't rein in their employees, if they knew that they were unfortunately harassers and perpetrators of sexual violence or sexual harassment in the workplace.
It's always it's good to incentivize folks to act rather than not, right? So. Got it. And then were there any changes to those laws or any other leave laws in Illinois that you wanted to cover? To VESA, for example?
So with respect to VESA, there's now a 10-day requirement. I don't know if this is what you're getting at.
I think so, yeah.
If, let's say, someone, I think, passes away.
Yeah, the bereavement law changed.
Well, the bereavement law, there is a bereavement law in the state of Illinois that was recently passed.
Child Extended Bereavement Leave Act and Family Bereavement Leave Act.
Yes, but that doesn't necessarily apply to all employers because you need 50 or more employees. It's similar to rights under Family Medical Leave.
Got it.
So if an employer is subject to the Family Medical Leave Act, then yes, they have to extend those rights to, let's say, someone who does have a child who passed away, or let's say a child who was subject to like gun violence or whatnot, and that has expanded to, I believe, most employers, if I'm not mistaken. But if you are going to, let's say, take leave or extended leave, and you want to use FBLA or the Child Bereavement Leave Act, those do require larger employers, like 50 or more employees, to be effective.
It makes sense. Smaller employers are probably not set up to handle unexpected leave like that or lengthy periods of
Right.
losing one of 10 people.
But keep in mind, though, that if you do work for an employer that is large enough to have both FMLA, and if they are large enough to have FMLA, then they are going to be large enough to have the family bereavement leave and whatnot. You can't, let's say, take 6 months off from work. They are going to overlap. So if unfortunately you had to have surgery that year and you needed to leave, be off of work for like 3 months, and then unfortunately you had a child who died in the same year, which is an awful situation, you might not necessarily be able to take 6 months off of work, you know. So there is a little bit of overlap between those two.
Which makes sense.
Yeah.
A lot of these leave laws tend to be where you can't just stack up one on top of the other. Chuck, turning back to you, the minimum wage is often a hot topic in our city, and it seems like every year on January or July 1st there's a change. So what's in store for us this year? Are there more changes to the minimum wage law coming?
Yeah, so we have now, I think, a minimum of $15, or it's like $15.80 in the city itself. And then they're also talking about getting rid of the tip credit, which is, that's going to be a major change, a major shift. So basically, it's the idea that a lot of employers have been cheating employees out of the tips by using like managers who share with the employees their tips and things like that. They're going to, looks like the city council is going to get rid of that credit, and they're going to basically go with a more stringent way of enforcing or applying the tip applying wages to tips and how they get divvied out.
So the tip credit basically being for folks who, if you normally earn the full minimum wage, whether that's 15 or wherever you work, but you're in the service industry or an industry where there's tips are typically applied, right?
Yeah.
Employers can pay you less than the regular minimum wage as long as with your tips you're regularly hitting at least the minimum wage with that time.
Yeah, I
right?
think it's a few dollars less
Yeah.
Per hour for the tip credit, yeah.
Yeah.
So it looks like they're going to get rid of that.
At the federal level, I think it's still like in the threes, so it's still very low.
Well, the federal minimum wage is what, $7 or $7.25, I think?
It hasn't changed for about 15 years, yeah.
Yeah, I mean, so that's largely only in the red states and in the South. So
I think there are only 2 states in the entire country that might even go by the federal minimum
Really?
wage. Yeah, I don't think it's any more than that. Even in some of the red states, it's crazy. Usually most have state minimum wage laws that are much, much higher.
well, you're looking at now. There's a lot of states that have gone to $13 to $15 an hour, but then there's also a greater push now to go to up to $20 an hour.
Sure.
So I think that's going to be where the ceiling is headed, is $20 an hour.
That makes sense. So just before we wrap up, there were some other laws at the federal level that aren't necessarily employment specific, but are important and that companies ought to be somewhat aware of. The Corporate Transparency Act, does either of you want to take a bite at that one?
Yes, very, very important. And I have my own business, so even from a personal perspective, I myself, for my own business law office, it's Helen Bloch PC, I had to comply with this. So basically, the feds passed a law because they are trying to better protect us as taxpayers and whatnot from, let's say, fraud, offshore investments, folks starting shell corporations. And so what the government decided to do is anyone that basically that is not a Fortune 500 company and a few other exceptions must file with the federal government in terms of if you have a corporation or an LLC or a certain kind of a trust, condominium association, who the beneficial owners are. So who are your board of directors? Who are the owners of these various business entities? And I did this already this year. So basically, I can say personally what is required. So any business that was started before December 31st of 2023 has until this entire year. So essentially until December 31st, 2024 to register. You go on this federal website and you have to upload either a passport picture or a driver's license, but a government-issued photo identification. You have to provide your address and some other personally identifying information for all the owners of the business. For any business that is started essentially January 1st through ongoing, okay, because now that the law is in effect, you have to register your business within 90 days. So all the beneficial owners have to register that new business. And where it's going to become a little bit sticky is that what happens if the beneficial owner moves or changes their information? My understanding of the law is that you have to make those updates to what's called FinCEN. And I forgot what that acronym stands for, but it's essentially the federal government.
Financial Crimes Enforcement Network.
Thank you. That.
Good assist.
That. You have to update your information. So I have, I'm a registered agent for a lot of businesses, and so when I've sent annual reports now to my clients this year, I've included the link to FinCEN to submit their BOR, their, what does it stand for?
Beneficial ownership information.
Thank you. That. And that's basically how I've handled it with my business clients.
Got it. So these are largely new reporting requirements for businesses. New businesses have to do it right off the bat, but if you're an existing business that was around prior to New Year's Eve last year, you're grandfathered in until the end of the year.
Exactly. You've got a year. So for instance, I have one client who said, you know what, I'm gonna move. I might even be moving out of state. And I said, well, I filed her annual report, and I said, look, keep this in mind. You have a year, but why don't you wait until you move, so this way you don't have to update your registration.
So what happens if somebody does not comply with this? What are the consequences?
There are steep penalties. If the Fed finds out that you have like an LLC or a corporation, which keep in mind, if one has an LLC or corporation, these are publicly available documents through the Secretary of State.
Sure.
So I don't know what the Feds are going to do to track this down, but it is publicly available. And there are steep penalties if you fail to register. Financial penalties. There could be criminal, I just don't remember off the top of my head, but there are definitely steep financial penalties for failure to register. And the registration is really simple. I did it myself. It took like less than 5 minutes.
And so I think, and you hinted at this at the beginning, the reason for this law, right, is what exactly? It's tax related, or it's...
Yeah, essentially it's to protect, let's say, fraudsters or drug activity and other crimes from, let's say, creating LLCs or corporations that are really sham corporations used to funnel money, let's say abroad, for example, or to use for nefarious purposes or to hide money.
Got it. So like
Russia, literally, that's one of the purposes, like money laundering for Russia or drug cartels, things like that.
Got it. So
and other like international interests, Iran, whatever.
Sure. So we have OFAC for that, right? So you're not allowed to do business with certain countries, right? Or there are certain rules about that. And then I think what you're saying, right, is the idea is you set up some empty shell corporation that has no employees, doesn't really do anything. It has some generic corporate, corporate LLC kind of name, Acme Corporation, and basically exists to help funnel money through or you don't even know who all those who are involved, who are necessarily the members of the organization, because you don't necessarily have that on the Secretary of State website. You might just have one, like a registered agent or maybe one member who filed, but the entity could have a lot of members. And so whoever has a beneficial ownership now is supposed to have their information submitted to FinCEN. But there are some companies, for example, and trucking companies come to mind, right, where one company might have the name Helen's Trucking Company, but not all of the business is done under Helen's Trucking Company, LLC, or what have you. One LLC might exist to own the trucks or lease them to drivers. Another might exist for interactions with brokerages. So if you have a company that's made up of 3 or 4 different companies, do you need to report every single one of them the same way?
Every single company has to report who its beneficial owners are. So every LLC or corporation, unless you're one of those exceptions, so essentially, unless you're a Fortune 500 company and a few others, banks, whatnot, you have to report for every single LLC. Every single corporation must report.
You heard it here. Well, Chuck and Helen, thank you so much for sharing your expertise and walking us through a few new obligations and rights that employees and employers alike do have in the state starting, a few weeks ago this year. Thanks to everybody at home for watching and listening, and tune in again soon.
Thank you.
Thank you, Max.